Comprising more than 17,000 islands, Indonesia is a vast archipelago with a population of around 255 million people. These people represent a significant array of cultural, ethnic, religious, and linguistic diversity, all united under the Indonesian flag with the motto of Bhinneka Tunggal Ika, which translates to unity in diversity. Keeping the order in the country is Indonesia's legal system, a civil law system intermixed with customary law and the Roman Dutch law, based on the 1945 State Constitution of the Republic of Indonesia. To understand Indonesia's current laws, you need to go back to the Dutch colonialism era that formed Indonesia's modern law system. During the 18th century, the Dutch United East India Company had established itself as the dominating economic and political power in Java, after the crumbling and collapse of the Mataram Empire. In the 19th century, the Dutch East Indies developed into a profitable colonial empire in modern Indonesia. To facilitate its trade and political economic interests, the Dutch established the Roman Dutch civil law legal system. With this, the Dutch adopted several laws like the Reglement op de Rechtelijk Organisatie et het Beleid der Justitie, or Regulation of Judiciary and the Policy of Justice, abbreviated as RO. The Algemene Bepalingen van Wetgeving, or the General Provisions of Legislations, commonly abbreviated as AP, and many more. Under the Dutch colonial law is the concept of legal pluralism. Legal pluralism was established upon discriminatory racial principles of the three classifications of people in the Dutch East Indies: the Europeans, the Foreign Orientals, and the indigenous Indonesians. The Europeans were people of European descent, and the Japanese. The indigenous Indonesians were all native inhabitants of Netherlands, India, who did not change their status into other groups, and those who were people of other groups that have absorbed themselves into the native Indonesian people. Meanwhile, Foreign Orientals were those who were neither Europeans nor indigenous Indonesians, like the Chinese. These three groupings have different laws and courts that apply to them. This is outlined in paragraph 1 and 2 of Article 131 of the IS, where the Dutch Civil Code, Commercial Code, and other existing laws in the Netherlands apply to the European grouping. And for the indigenous Indonesians and Foreign Orientals, customary law was applicable unless it was not superseded by ordinance. And indigenous Indonesians are given the option to supersede customary law in the areas of private and commercial laws by submitting voluntarily to European law. As mentioned briefly before, people born into certain groupings were allowed to convert their status into another group or submit to a certain group's law. Those who wanted to convert their status into European should file with the Governor General, where they can be granted equal status as Europeans and apply European law. On the other hand, a European or a Foreign Oriental who, in short, behaved as if a native Indonesian and felt to be an Indonesian could be converted to an indigenous Indonesian. The rules of legal pluralism caused a multitude of complications based on the groupings, as the legal conflicts involving people of different groups may raise legal issues of which court and which law applies.
When the Dutch colonial government surrendered to the Japanese military, Indonesia started to prepare for independence and drafted a constitution. On August 17, 1945, the Proclamation of Independence was announced, and on the next day, the Indonesian law came into place, discontinuing the colonial legal order set up by the colonial ruler. The law adopted was the 1945 State Constitution of the Republic of Indonesia, which is the basic law upon which every law and regulation should be based. Since the 1945 Constitution is supreme, all laws and regulations should follow. Consequently, all laws and regulations produced by the colonial rulers should not be applicable anymore because they contradict the Constitution. However, the Indonesian government was not enacted laws covering any sector of daily life. So, as to not create a legal vacuum, the Dutch civil codes and the colonial laws were still carried on through a transitory provision that was incorporated into the 1945 Constitution. The provision states that every law and regulation that was in power before the war, provide that they do not contradict the spirit of the 1945 Constitution, are applicable unless substitutes of the respective law and regulation have been passed by the Indonesian government. With this discriminatory practice in law, practices by the Dutch were abolished. With the law in place and a form of government based on unity were established in the constitution, Indonesia was optimistic of political stability. However, political stability was far from reach. The Dutch and Allied forces ignored Indonesia's declaration of independence and returned to the country. Defending their independence and territorial integrity, the Indonesian people took up arms against the aggressor in guerrilla battles and held multiple conferences with the Dutch that resulted in the creation of the United Republic of Indonesia. The Round Table Conference of 1945 produced a draft constitution for the federal state, which was ratified on October 29, 1949 by signing a Charter of Agreement. This agreement did not last long. The constitution changed once again to what was called the 1950 Provisional Constitution. With this, Indonesia returned to becoming a republic, favoring a unitary state more than a federal. But that constitution was still not right. Hence, the return of the 1945 Constitution once again. With his withdrawal came the reform era, putting in place laws and safeguards to avoid such abuse of power to happen again. Among other things, these amendments deal with far-reaching issues such as limitation of power and term of office of the president, decentralization of the central government's authority to provincial and regional governments, and creation of additional state bodies such as House of Regional Representative, Constitutional Court, and Judicial Commissions.
Now, the Indonesian legal system is still based on the civil law system and the 1945 Constitution, a basic law of Indonesia that no other law should contradict. Under the Constitution is a hierarchy of other laws, starting from the People Consultative Assembly Decree, then the Law or Government Regulation in lieu of law, Government Regulation, Presidential Regulation, Regional Regulation, and finally the Regency or Municipality Regulation. Indonesian law today is ever-changing and growing. More and more laws are being codified, ridding the country of its colonial past to fit today's context and Indonesia's vision. Since the new order, the Constitution has been amended 4 more times. With this, the law changes alongside the changes in society. What happened next to Indonesia's legal system? There is no way to tell.